In most cases, when two parties enter into a contract, we draft contracts. And when we draft, the purpose of drafting contracts is to allocate risks. And when these risks are not clearly assigned to the people that are able to handle, for instance, when you bring in contractor, like for the FIDIC, the Red Book, the 1999 one, the responsibility of design lies with the client. If you shift that to the contractor, then, I mean, is the contractor able to handle risk of design? And if at all he is not able, then who is appropriate to handle the risk? When it comes to payment and such kind of things. So when drafting contract document, you allocate risk, assign risk to respective parties that are able to handle them. That when these risks are not properly assigned, it leads to something we call conflict. Conflict is simply like not moving at the expected pace in contract, or just something that need to be relooked into. And if at all they are not properly managed, then eventually you will hear the contractor raising claims. Claims can be in terms of other damages. Contractor can raise a claim on extension of time. Contractor can raise a claim in terms of financial compensation and such kind. And if these claims are not properly resolved or properly handled, then eventually we have a dispute. It is important for engineers to understand how the process of the formation of dispute and how they can be handled. I put in this slide, but not really to discuss it further, because my colleague, Engineer Kariuki Mshemi, will give us probably more about arbitration and unilateral model law. I put this one to give us a global outlook of ADR practice. Arbitration is well developed, well defined globally compared to adjudication, which also will be discussed extensively by my colleague, Engineer Mbugwa. But I gave out these three critical papers or three critical documents that define the practice of ADR worldwide in the industry. There's the Geneva Protocol on Arbitration Clauses of 1923. Then there's the Geneva Convention of Execution of Foreign Award and New York Convention of 1958. This document will be discussed briefly by my colleague, Engineer Kariuki Mshemi, how they form part and parcel of the ADR practice in the industry. I'll come home and ask us engineers, why are we talking of ADR? What is the legal background? What is the legal basis? Our Constitution, Article 159(2), provided clearly, and this one is what formed the basis of ADR practice in this country. At any given time in the courts or wherever place when ADR is mentioned, the basis is our Constitution, Article 159, subsection 2, that talk of, in exercising judicial authority, the courts and the tribunals shall be guided by the following principles. Justice shall be done, irrespective of the status. Justice shall not be delayed. And then specifically for the purpose of the dispensation of arbitration, adjudication, mediation, conciliation, traditional justice system is anchored in Part C. Alternative forms of dispute resolution, including reconciliation, mediation, arbitration, traditional dispute mechanism system, shall be promoted subject to Clause 3. Clause 3 talk of equal rights, technicalities, and such kind of things. So as we talk about ADR, as we talk about mediation, as we talk about arbitration, whichever, it is properly anchored in the Kenyan Constitution. And the legal framework of ADR in this country, of course, it is still growing because we have the Arbitration Act, we have the mediation bill, it has not been executed. Then we have the construction and adjudication bill that my colleague will talk about. It is also in the process of being developed. But the foundation of ADR practice in Kenya is anchored in our constitution. What is the spectrum of ADR? By spectrum, what do I mean? How is it characterized generally? And if we look from the left, I have a graph here. You know, engineers also, have no problem getting information from straightforward graph like this one. There is the maximum and the end, and the minimum. What does this mean? At the beginning of ADR engagement, we have what we call party control. Party control, we have the lower cost, the formalities, cordial relationship, speed, and flexibility. That is on the y-axis. Now, on the x-axis, I've put in a number of ADR mechanisms, negotiation, and the rest. But let me discuss one by one. At the point when the two parties come to negotiate, they have the maximum control of what they are discussing about. They have maximum control of their dispute in terms of cost, in terms of formality, in terms of speed, flexibility. They can negotiate at pleasure. Time, venue, anything. They can decide over how even their dispute will be solved. They can even come up with some new, invent some solutions that are not even within the law. Then as things move towards the end, you see there is mediation. I'll discuss further when I get to discuss the ADR mechanism. When parties move to mediation and early neutral evaluation, you can see the way the graph is moving. Your power and control for the cost and formality started to reduce, to come down. As things probably get harder or get tougher, or each and every party try to tighten their belts or harden their stance in the dispute, and you get to the medium part of my graph. Of course, without prejudice, which means anything you say at this particular time cannot or may not be used against you. So we find there's been trial or executive tribunal. We have made arbitration. Now, as you move towards the end, you find that your control as parties reduce drastically as you head towards arbitration. And eventually, when you get to litigation, you absolutely have no control on the cost of how much your dispute is going to take to be resolved. You have no control on the formality. You have to appear in court. Court, you must be represented. The speed at which. So this is the spectrum of how ADR mechanism evolve. And it is important for the practitioners to understand this. The more you move, the more you lose control, and the more you find yourself that now you'll have to just submit your case to the court for litigation. Now, how this ADR mechanism, what are their characteristics? They're generally non-binding. Negotiation, you can negotiate, agree on a settlement, but then it depends with the willingness of the party, because you may move from there and then the following day the party again changes mind or something like that. When we shall talk about even mediation basically is based on the parties' agreement. And at the end of the day, the execution of the agreement is another contract altogether. The parties make a decision. Then it is voluntary. Nobody will put a gun on your head that you must go for mediation, you must go for arbitration. ADR mechanisms are voluntary, unless anchored in law. In other jurisdictions, like the UK, they have a legislation they call the scheme, which mandates that in any construction contract, there must be an adjudication clause, and without it, appointment and the execution, then the state adjudication applies. But for our country in Africa, I think generally we don't have anything like that. All our ADR are voluntary. ADR, they can either be with an intervention of a third party or without intervention or assistance of a third party. In a context like negotiation just the two parties, the contracting party just sit, talk, discuss, and agree. When we move to mediation, then you call in a third party or somebody to assist you. I'll explain a bit of it later in my presentation. And now when it goes down to arbitration, then definitely you have to have a new role called an arbitrator to come in and arbitrate your dispute. Then when it comes to enforceability of the settlement, it is purely on agreement of the parties. If we agree that, okay, on this project, yes, time extension, we agree, I'll give you time extension of 2 months, but at this cost, or time extension on this, it is purely on your agreement. Of course, at the end of the day, one party can decide, no, I need better, or I'm not comfortable with what you place on the table, and such. So enforceability is purely on the willingness of the parties. Then, as I discuss more on the characteristics, there are some few advantages ADR present in general. There is the element of satisfaction of the outcome. Let's take for mediation. Mediation is a win-win process. So at the end of the day, in most cases, you find that the parties will shake hands and say, thank you so much. Because I've gotten what I wanted, the other person is also satisfied with the outcome. He has also gotten what he wanted. And everyone will go home. I was discussing about the advantages of ADR and talked of flexibility in terms of the meeting time, meeting venue, and such kind of thing. We can decide that, yes, we are contracting in Nairobi, but then we are going to meet in Kisumu to resolve our issues. There is the element of privacy and confidentiality. You know, when matters goes to court, then definitely it is now in the public domain. And you cannot tell the judge that, please, I don't want this issue to be discussed in national court, but instead I want it to be discussed in your chambers or something like that. That one doesn't happen in our country. But with ADR, in mediation, you can decide, or in arbitration, you can decide, yes, I only want the parties, or parties will decide that we only want to be the two of us, the contracting parties, and the tribunal. And that is it. It will happen like that. There is the element of affordability. What am I talking about? Affordability. Parties have control on the cost of how much they are going to pay to the arbitrator. What is known is that in litigation, in most cases, you are represented by a lawyer in court. But in arbitration, you read clause 25 says, anybody can represent any person in arbitration process. So you have that flexibility. You can control the cost. You can decide Engineer Lochia is going to represent you in matter of construction arbitration on this matter, or you can just go yourself. So that is an advantage, because now you save on the legal cost. There is the element of speed. You can decide we want to meet for 5 consecutive days until this matter is resolved, or we are going to have it spread within 1 year. Or that is. There's the element of preservation of the relationship and future engagement. You know, when you go through a mediation, at the end of the day, you shook hands. Definitely in the next year or the next engagement, you will still wish to get into business with such a party. So that is an advantage in ADR. And the way I had said earlier, It is a win-win situation. Everybody goes home happy. Everybody goes home smiling. Yeah. I'll discuss ADR mechanisms. I've listed around 10 of them in number. I'll discuss a few of them, and the rest will be discussed in details by my co-presenters. There is negotiation. Negotiation, as I said earlier, it is just a situation whereby the parties come together and say, yes, this one has happened. What can we do? What is it that you want? What is it that I need? Everybody presents its case or her case in a more candid way for the other person also to understand, and then they agree on how they are going to settle the difference. Then if at all that one fails, then the parties can decide to go to mediation. Mediation then simply means that the parties call another neutral person, a third party. It is better if the third party is trained and is able to understand the subject matter. So let's say a contractor and probably a client differed on something. They can call in a consulting engineer or an engineer to help them, bridge their difference. So mediation is just an aided negotiation by a third party. This third party doesn't propose any solution. He'll just assist the parties to come together to talk and settle their issue. Then there is the conciliation. Conciliation is now whereby the conciliator can propose for a solution or for a settlement in the context of, he will say, okay, well, as much as you are asking for 3 million, in my opinion, I tend to think if you take 2.6 million, it will be a good settlement. It will be something good. You can go home with it. The conciliator is allowed to propose for a solution, but the mediator is not allowed. I think that difference must come out very clear. Then there is the expert determinant or expert witness. Expert determinant is also another third party, but this third party must be well trained in the subject matter. You cannot go and call a QS to come and determine the structural integrity of a bridge. He cannot be termed as an expert determinant. The expert determinant makes a determination. But then when it comes to the expert witness just helps the arbitrator to clarify or to bring in the subject matter into clear perspective. The expert witness must be somebody who is trained in the subject matter. And as I've given an example, a QS being an expert witness in the determination of the structural integrity of a bridge is not proper. I don't want to delve into others. Then there is the neutral evaluation. This is just to discuss much about the dispute and just understand, evaluate what exactly happened and how exactly parties can settle it. Then there is the dispute review board, dispute avoidance board, and dispute adjudication. I'll put them together simply because this is just a board. Board can either be one person, 3, 5, or odd number. That
Engineer, we have 2 more minutes.
Thank you. I'll finish in a short. I hope 2 minutes will be enough. So the dispute board, this is a board that in FIDIC and in other jurisdictions, they are supposed to be appointed at the beginning of the project. Of course, some are appointed when dispute has occurred. But then when they are appointed, the disputant or the party submit to them their issues their issues in details, and then they'll look at it. They assess in either dispute avoidance, or they'll review the dispute and make a determination. And that one pushes me to now to adjudication. Adjudication is whereby the neutral adjudicates over the matter. In the context of the two disputants submit their disputes or their differences, and to him, then he looks at the evidence, he looks at the facts, he looks at the law, and then make a determination. There is another mechanism called mini trial or executive trial. This one I've seen is so common with the fraud authorities, or sorry to mention, whereby you find that when the dispute occurs and they have discussed, they submit it to their seniors, the director general, and probably at the senior most level, the CEO of the contractor and all that. And the seniors just sit down and make and decide on how to address that difference. And then there is mediation, arbitration, or arbitration, mediation. I've explained about mediation. I'll get to arbitration. Arbitration in Kenya, my friend, colleague will talk much about it. Is a bit developed, but I'll leave it at that point so that Mbuga can have a opportunity to talk. Karaoke can have more opportunity, more time to talk about it. Mediation, I've talked about it at length. I don't want to say much about it. I want to conclude by addressing my item number 5, the role of engineers in ADR. Engineers are key people in the project, from the planning, execution, and closure. FIDIC, we all understand the position of the engineer in FIDIC contract. Engineer plays a critical role on 3 aspects in contract. I'll say 1, as an expert witness; 2, as an expert advisor; 3, as an is also key in dispute avoidance and dispute review. Those are 3 key fundamental roles, and in FIDIC they are well elaborated, and engineer can play a very key role in that. So I pray that even as we make this introduction, you will consider the ADR industry, and the more the engineers in this industry, I'm very sure the more efficient way we shall be implementing our project and probably handling our disputes. As a practitioner, I think I've come to realize that the infiltration of lawyers into this sector has made this industry a bit complex and has made engineers run away from dispute. But I wonder, at times we are the creators of these disputes. So I invite all of us probably to engage